Final case of the call is People versus David Ames. This case is also an argument on the application. You each have 15 minutes, and you may reserve time.
Good morning. May it please the Court. Marielena David Martin from the State Appellate Defender Office on behalf of Mr. Ames and co-counsel Jacqueline McCann at table. The level of appellate review of within and without guideline sentences influences the advisory nature of the guidelines. In Booker, in order to make the guidelines advisory, the court had to sever two provisions of the federal guidelines. First, the provision that required a within guideline sentence absent justification, and as we know, this court did that in Lockridge, severed a similar provision of the Michigan State Guidelines in Lockridge. But more importantly, for this case and for this analysis, what the court did in Booker is they severed the provision of the federal guidelines that required a de novo appellate standard of review for outside of guideline sentences. And that's very important to this case. The court reasoned in Booker that a guideline scheme that provides for more deference and less appellate scrutiny for within guideline sentences than for without guideline sentences renders the, quote, guidelines sentencing even more mandatory than it had been, end quote. So the level of appellate review given to outside guideline sentences in comparison to the level of appellate review given to within guideline sentences can, in fact, create a mandatory guideline scheme when the guidelines are supposed to be advisory. And Section 34, subsection 10 does just that. The Sixth Amendment violation persists here because judicial fact-finding is authorized to establish not only the range of sentencing, but also the range of unreviewability of that sentencing. The prosecutor compares the guideline range merely to a safe harbor that the trial court judge is free to choose between. But the prosecutor ignores the role of the trial court in setting that safe harbor. Trial courts are able to, as we saw in the Walker case, say that they want to score certain variables, OV19, for example, in that case, because they're creating a different range. When they go within that range, this court, the appellate courts, are unable to review that sentence. So the danger of the Sixth Amendment, violating the Sixth Amendment, persists when we allow trial courts to find facts that increase the sentencing range, and then we say, you can move the safe harbor, you can move that range wherever you want through judicial fact-finding, and then my decision as a trial court judge to sentence within that range is then insulated from any type of appellate review. 3410 requires sentences to be upheld as reasonable, again, only because of that judicial fact-finding. And in Booker and Rita and in Gull, the federal line of cases that this court should look to provide a remedy for Mr. Ames, all of those cases support the position that the dynamic between a within guideline sentence and a without guideline sentence of appellate review really does create a de facto mandatory guideline scheme.
Counsel, the question here really isn't for us isn't whether the Sixth Amendment is violated by this particular statute. It's really how does keeping the statute in place affect our remedial holding in Lockridge, right? So it's not exactly, you're not really arguing to us that this statute violates the Sixth Amendment, correct?
Well, I'm arguing both, that it doesn't effectuate the Lockridge remedy and that it also violates the Sixth Amendment, and I can talk about both of those things. The Lockridge remedy certainly is not effectuated if 3410 stays in place, because in Lockridge, this court wanted to make the guidelines advisory. It wanted, and it established sentencing standards for review, which was that sentences in Michigan should be proportionate. They should be reasonable to the particular offender, to the circumstances of the crime. 3410 prevents that standard to have any type of effect, and it prevents the actual advisory nature of the guidelines, which is why I say it is still a Sixth Amendment violation. The court in this case should finish implementing the Bookerization of the Michigan sentencing guidelines by severing 3410. That really is a crucial piece of how the guidelines in our state can truly act in a mandatory fashion. The federal line of cases, Rita and Gall, support this analysis because Rita established that it was okay to have a non-binding, rebuttable presumption of reasonableness for within guideline sentences. But 3410 doesn't have any of those characteristics. 3410 requires appellate courts to affirm any and all sentences within the guidelines, again, a range that's created by judicial fact finding, even if that given sentence is not reasonable or proportionate to the individual. That's inconsistent with what this court set up in Lockridge. And further, in Gall, the court said that there cannot be a presumption of unreasonableness for outside guideline sentences as well, and that all sentences, whether within the guidelines or outside of the guidelines, had to be reviewed for reasonableness. These federal cases, Booker, Rita, Gall, they all boil down to a simple proposition that a system that makes it harder to impose an outside of guideline sentence and easier to appeal an outside of guideline sentence places the thumb on the scales to encourage a sentence within the guidelines that is unreviewable and, again, creates a de facto mandatory scheme.
It doesn't literally require the trial court. I mean, nothing about this particular statute literally requires the sentencing court to impose a within the guidelines sentence. So how do I know that it's truly coercive?
Because literally nothing in it, if you go back to Lockridge, there was still the valve and the mechanism that guidelines didn't have to be followed if a court was able to give substantial and compelling reasons for going outside of the guidelines. So, I mean, you could say literally that wasn't requiring it either. And the same thing is in play here. An advisory guideline scheme can still have characteristics of being mandatory that this court should be very, very concerned with when it, again, provides an inducement to say, for a trial court to say, even though I think, this person should get a sentence outside of the guidelines, it's just much easier and safer to impose a sentence within the guidelines that's not going to be reviewed. And it creates arbitrary results. It creates unfair results. In this particular case, Mr. Ames received a disproportionate sentence because he got a sentence at the very top of the guideline range that was 3 times higher than his co-defendants. And because of this statute, he's not able to make any type of challenge to the proportionality or the reasonableness. Would he win that particular challenge? I don't know. Would any other individual defendant win that challenge? I think it'd be very, very difficult, and it would be the very, very rare case that an individual would be able to come in and say, my guideline sentence is unreasonable. And the courts recognize that in the federal line of cases, too, that it would be a rare circumstance where that would happen. Mr. Ames presents that rare circumstance where he is equally culpable as his co-defendants. He expressed remorse at the time of sentencing to the victims. He agreed to pay restitution that he didn't have to pay for dismissed charges. And he put himself through rehab and turned himself into police prior to even being charged with this crime. So those circumstances are present in this case, and an appellate court should not be prohibited from reviewing the reasonableness of a sentence imposed when there is such great disparity between the individual who gets the sentence and the co-defendants who are similarly situated. That's really the heart of what this court established in Lockridge was sentences must be proportionate, and they must not result in disparate sentences between similarly situated individuals. But Section 34, subsection 10 is really preventing the court from fulfilling the purpose of that guideline scheme. The other important factor I think that we should remember in terms of the guideline violation here, and the reason that within guideline sentences should be reviewable in the same way that outside of guideline sentences should be reviewable, is again because this court was attempting to Bookerize our guidelines, and the only way that the court can continue to do that and to take the steps towards to really fulfilling that purpose is to sever this portion of the statute. It's comparable to what was done in the federal line of cases, and it works the right result to give individuals like Mr. Ames and others an ability to challenge their unreasonable sentences.
Would you like to reserve the balance of your time?
Yes, please.
Thank you, counsel.
Your Honors, and may it please the Court, Assistant Attorney General Linus Banghart-Lynn on behalf of the people, and I'm joined at council table by the Deputy Solicitor General, Eric Ristusha. Your Honors, this Court should deny leave to appeal or affirm the decision below because Section 3410 does not make the guidelines mandatory. It does not expand or restrict the options available to the sentencing court when it passes sentence, and it doesn't violate the Sixth Amendment, Lockridge, Elaine, or Apprendi. The guidelines are in place with the purpose of trying to reduce sentencing disparity, and the guidelines do exist to try to encourage trial courts to sentence within them. Now, I'm not sure if it's clear that Section 3410 does actually encourage trial courts to sentence within the guidelines. It's a section directed at the Court of Appeals, and I think that post-Lockridge and post-Steenhouse, trial courts should be feeling free to impose the appropriate sentence after not disregarding the guidelines, of course. Lockridge says you have to score the guidelines, you have to use them as a starting point. But we don't presume that a within guideline sentence is reasonable. The trial court doesn't. And the trial court is tasked with imposing a sentence proportionate to the offense and to the offender. Now, there's some common ground here. I agree with my sister counsel. What makes the guidelines mandatory is the level of appellate review available to out-of-guideline sentences. And so if there is a presumption of unreasonableness for out-of-guideline sentences, then that's a problem. But reading Lockridge and Steenhouse, there isn't. And if the Court of Appeals is applying such a presumption or treating out-of-guideline sentences as unreasonable, then that's a problem in those cases. The availability or non-availability of appellate review of within guideline sentences does not make the guidelines mandatory. That is, as we have said, a safe harbor. To say you can do something, you can do these two things, and if you do one, you won't get reversed, doesn't say you have to do them. And we have examples in our brief of things that the trial courts can do with no possibility of being reversed. And yet we would not say, no reasonable person would say that a trial court has to do these things, that they're mandatory simply because they are permitted and not subject to appellate review. To the extent my sister counsel has argued that any asymmetry in review of within and without guideline sentences acts to keep the guidelines mandatory. And we know this is incorrect because in the federal system, post-Booker and post-Rita, there is a recognition that the courts of appeals can apply a presumption of reasonableness. Now, that is a little different than what we have here, but there is still an asymmetry in the federal system. The within guideline sentences, the appellate court, not the trial court, can apply a presumption of reasonableness to these within guideline sentences, will not apply that presumption to out-of-guideline sentences. And that doesn't offend the Constitution, that asymmetry. And in fact, even if this court were to strike down Section 3410, we would still have an asymmetry. I think it's going to be natural that the Court of Appeals or this court might adopt a presumption similar to Rita, a non-binding presumption, or would just simply, in the course of reviewing sentences, treat within guideline sentences as reasonable. And that doesn't make them mandatory.
So you might have lost me just in the last bit, so let me have you slow down for a minute. So, obviously, if it was just a presumption of reasonableness, you probably wouldn't be here, right? The question is, does this statute, as it's written, effectively make those within the guideline sentences unreviewable, and does that somehow make them mandatory? Or does it at least, undermine the Lockridge remedy?
I agree with you on the first part of the question. Rita forecloses that argument that if it were a mere non-binding presumption. Exactly. The fact that it is binding, Rita didn't hold that it was only allowed because it's non-binding. The presumption in Rita was non-binding, and that's something that the court discussed. But I don't think that it
was important to the court's decision that it was non-binding, right?
I don't think it was important to the court's decision on the Sixth Amendment question. I think what makes that important is because you're talking about the U.S. Court of Appeals. If it were a binding presumption, you would have a case where the U.S. Court of Appeals is taking it upon itself to abdicate part of its role in reviewing sentences and saying, we know our job is to review judgments of the lower courts, but when it comes to this particular set, we're not going to do it at all. And I think that would be that's not a Sixth Amendment problem, but I think that is a problem. When the legislature, the Michigan legislature, which holds the ultimate constitutional authority over sentencing, tells the Court of Appeals, this class of claims, you do not review these, or you review them, but you affirm them. I mean, we're dictating the result. That's a different question than if the U.S. Court of Appeals had created and then applied a binding presumption of reasonableness. So I think the fact that it's non-binding is important to the fact that it's judicially created. Here we don't have it judicially created, and so whether you describe it as a presumption or not is a little bit more of a question of form, because it does have the same effect that a binding presumption would. But again, it's created by the legislature, which has the authority to set sentences, to delegate its discretion the way it sees fit, both to the trial courts and to the Court of Appeals in terms of how we treat sentencing. And the legislature has chosen to delegate a fairly broad discretion to the trial courts. And the fact that the trial court can find facts and score the guidelines as the legislature has commanded and change its own safe harbor, which is the point that my sister counsel made, is that, yes, it's a safe harbor, but the court can increase its own safe harbor by finding facts. I mean, there's a couple of problems. First of all, moving the safe harbor doesn't change the sentences that are available to the trial court. The trial court can sentence within or without the safe harbor. What it does is it changes the discretion, the ability of the Court of Appeals to review it. And that's not the same. That doesn't make the guidelines mandatory. Second of all, the suggestion that a trial court would strategically score or not score guidelines in order to change the appellate reviewability of its decision, I think is wholly inappropriate. I think it's disrespectful to trial courts. And second of all, if we're worried that a trial court is going to do that, the scoring of the guidelines is fully reviewable. 3410 has a carve out. If the guidelines are misscored, you can review that and you can review the sentence. And so you can look at the trial court and say, you know, we think that it strategically scored the guidelines this way, and the Court of Appeals can look at it and say, well, no, it scored them correctly. And the guidelines say score the highest among the range. So it's not a matter of that the trial court has the discretion to find facts, but once it has found the facts, the application of it is a legal question that the Court of Appeals and this court can review. So the point is that scoring the guidelines does not change, post-Lockridge, does not change what sentences the trial court is allowed to impose. It only changes, in some cases, what the Court of Appeals is allowed to review. In the briefing, the defendant has said that the trial courts enjoy a presumption of reasonableness for within guideline sentences. I think that Rita forecloses that argument. In Rita, we have an appellate presumption, and Rita says, and in Pugh later on, and Nelson, they say the trial court doesn't have this, the trial court can't have this presumption. And so if the presumption in Rita, which is an appellate presumption, created a trial court presumption, then Pugh and Nelson couldn't have come out the way they did, because they say you can't have a trial court presumption. So I think that argument is foreclosed by those federal cases. I think that addresses the points that I wanted to make. I would be glad to answer any questions that the court might have.
I see no questions. Thank you.
I thank Your Honors, and we request that the application be denied. Thank you.
Thank you, counsel.
Just 3 quick points. The prosecutor says that that 34 subsection 10 shows that the legislature made a choice to give the trial courts unfettered discretion in imposing a within guideline sentence. And I would say, yes, it did in a mandatory guideline system. That's where 3410 was created, to serve a mandatory guideline system. It does not serve an advisory guideline system. Second, of course, the trial court does have the discretion. They are allowed to impose a sentence anywhere, either within the range or without, but discretion means absolutely nothing without appellate review. How do we know the trial court judges are exercising the proper discretion without allowing some type of appellate review? It really is just crucial to an advisory guideline system. And lastly, I agree that the trial court cannot have a presumption of reasonableness. That's not, again, that's not consistent with RETA, and that's not appropriate according to the federal cases. And I wasn't saying in my briefing that it gives them that they do have a presumption of reasonableness based on this statute. What I was saying was that 34 subsection 10 improperly creates that dynamic. It improperly gives the trial court a presumption of reasonableness that it's not entitled to have, because trial courts do understand that any sentence they impose within the guidelines is unreviewable.
Can you explain yourself just in a little more detail as to what you mean by the fact that unless we have appellate review, we can't assure ourselves that the trial courts have exercised discretion? Doesn't the law entitle them to exercise discretion?
The law does.
Why do we need appellate review in order to sustain that premise?
Appellate review is necessary, especially in Michigan, because of the unique wide nature of the range in Michigan. Our guidelines have one of the widest ranges in terms of what's the low end and what's the high end. And so when we say to trial courts that you're free to pick any sentence within this range, that can create very, very different sentences for the same or similarly situated individuals. So that type of discretion really does require appellate review in order to ensure that the principle of proportionality and reasonableness is being fulfilled in sentencing. Thank you.
Thank you, counsel. The case will be submitted, and that completes the call.